So hello everyone, and this is our tutorial in Springfield, in Toowoomba for week 4. As usual, we're going to follow the Wentworth-Miller method in order for us to go through and identify the legal issues and then use ILAC. Let's start with this exercise. Mark had been dismissed from his job at XYZ Proprietary Limited. Mark was bitter because first he believed his ex-boss, Paul, had treated him unfairly. And secondly, because he calculated he was owed $5,000 in unpaid entitlements. To make matters worse, Mark had fallen and hurt his leg, which required him to move with the aid of a walking stick, while his leg recovered. A week after he was dismissed, Mark decided to break into XYZ's offices at night and take the petty cash which he knew was held in a flimsy cash box in the cashier's cupboard. Mark told himself this would go some way to recovering the money he believes he was owed. On arrival at the rear door of XYZ's offices, Mark was pleasantly surprised to find it unlocked. However, moments after Mark entered the building, he was challenged by George, the elderly caretaker, cum janitor. Mark panicked and hit George on the head with his walking stick, knocking him unconscious. Mark then hurried to the cashier's office. Neither the cupboard door nor the cash box offered much resistance, and Mark stuffed the contents of the cash box into his pockets without bothering to count. As Mark was leaving, he passed Paul's office and gleefully entered it to smash Paul's prized collection of sporting memorabilia. When Mark arrived home, now he counted the money and found it came to $10,000. Mark used the entire money, $10,000, to clear his credit card debt. 3 weeks later, the police interviewed him and charged him with aggravated robbery and criminal damage. All right. Advise Mark. So, negligence has 3 elements, right? What's the first element? That a duty exists, right? I can see a lot of Matryoshka dolls just staring at me. Well, yeah, great. So, where are we going with this? I said negligence has 3 elements. Anyone?
You're talking about Mark and Paul, how his first injury?
Yeah, which parties do you want to talk about? Let's start with the parties. Where are the parties here? Who is going to take whom if they go to court? Where's the conflict? Between whom and whom?
Between Mark, his boss, and the caretaker he assaulted.
So, let's do them in pairs. What's the first pair?
Mark and the ex-boss Paul.
Okay, Paul versus Mark. Okay? So Paul is going to argue, what does Paul want? Okay. Paul wants his money back.
Plus damages.
Plus damages for what?
For the memorabilia.
Okay, memorabilia. What else? Paul, what else would you want? The money back, the damage for the memorabilia, what else?
Any damages he had breaking in.
Breaking in? It was unlocked. Okay. What else? All right. What's the premise? What's the legal theory that Paul is going to use against Mark?
He was breaking and entering.
Trespass.
You don't want to use negligence?
Well,
No?
well, yeah, we can use negligence because a reasonable person wouldn't break into another person's place and steal their money.
But what does Paul want? Does he want to punish Mark?
Yes.
Criminal charges. And does that bring in any civil law?
No, this is
So negligence is irrelevant. And who is going to be the parties now? The Crown versus Mark, or the police versus Mark. You want to punish him. All right, I want to move quickly through this because this is from last week. So let's go and do some stuff from this week as well. The parties, the Crown and them, what do they want? Punish him for entering? Maybe. Okay, punish him for hitting George. Punish him for taking the cash, for smashing the prize collection. And of course, this is nothing to do with teaching you the criminal code here, at least in Queensland, of 1899. But you will be able to find these things on your own, I hope, because this is free online. Okay. One of them is this idea of breaking and entering. The key point for my purposes is that everything has elements. So you need to elementize. So when you read it, you'd say, for example, any person who enters any premises with intent to commit an indictable offense, so you need an indictment for it, in the premises commits a crime. Okay. Second, any person who enters any premises and commits an indictable offense in the premises commits a crime. Okay. All right. So as we said, every crime must have two elements. What are the elements here? Breaking and entering. The actus reus, the wrongful act, is entering any premises and committing an indictable offense. The rea is intention. Where did I get that from? From that section. So you can flesh it out, what is the premise, and so on and so forth. Let's move on to punishing him for hitting George. Hitting George would be assault. Okay? How do you elementize? So you take it from this section, definition of 245. So it says, so you have to elementize, you read it this way. A person who strikes George, the person of another, directly, because with the stick, okay, without the other person's consent, is said to assault that other person. That's it. On this reading, then you can have the elements of the actus reus to strike the person of another directly and without the other person's consent. The strike on the facts was with the stick, directly. Was it direct strike?
Yes.
Yes. Why yes? With what? So is that direct? If I hit you with a stick, is it the same thing as if I hit you with my fist? Okay. So it's connected enough to cause you to say that that hit was direct? No, leave the intent out because this is actus reus still. So you can argue around these things if you want. Without the other person's consent, we think that's made. If there is an issue here, it's going to be the directly. Not all the elements, it's going to be directly. And the intent, what do you think? Did he have intent to hit George on the facts? Okay, so however, moments after Mark entered the building, it says he was challenged by George. This part here. This part here. What do you read in this? Okay, Tim says he panicked. Sorry, what's your name? Fred? Frank. So you're going to have now this argument with Tim. Tim says he didn't have intent. Why? Because he panicked. What do you say to that? Do you agree that he didn't have intent? What do you think? Anyone? Anyone wants to challenge Tim? Did he panic? Yes. And then what?
He panicked, but he still chose to hit him on the head. So there's still intent.
So what is the argument that you are making? That after the panic, what happened? He could have created an intent to respond to that panic and hit him that way. The difference, of course, whether you hit him out of fear, so self-defense, or whether you hit him because you panicked and then you realized what's going on and you decided to hit him. Yes, any questions? Any comments? Let's move on. So all I want is for you to be able to pick some of these issues. That's all. So the issues here could be directly and intent on the facts. Now I go to the question and I change the facts, I change the issues. Okay? The elements will not change. What about this one? If I read it this way or not? Let's just move on. Taking cash, stealing. So the elements of stealing from definition. So you remove all of that. You don't need it. All you need is a person who fraudulently takes anything capable of being stolen is said to steal that thing. What are the elements? So we can talk about a person who fraudulently takes anything capable of being stolen. Actus reus is taking anything being capable of being stolen. And the mens rea, the fault, is fraudulently. Okay? So you can go back and argue those on the facts. Robbery, again, it has something. And you find the definition and you can find the elements. Okay? Robbery is always with violence. And of course there will be issues because things were unlocked. And what about punishing him for smashing this collection? Something called criminal damage. And again, you can elementize from the definition destruction of property, and it has to be done willfully. And where you find the definition of willfully and so on and so forth. It's like an onion. You keep unpacking. All right. His counter premises could be things like honest claim of right. Where does that come from? Because they owe him money. So it's my money. I will take it. So, all right. Let's move on to our torts for this week. Okay? If you have any questions about that, you can come back and ask later on. Let's look at this question from page 156. Okay? Question 6. Jean was a regular shopper at East End Four Corners supermarket. This is part of a larger nationwide supermarket chain. Why would they tell you that?
Just to show it's a big corporation.
So what? We'll see. Everything is there for a reason, right? It's not just like because we want to put words for you. Same thing in your exam. She was there at least once a week, and sometimes more often if specials were really good. She went there this week. Okay? She slipped on some grapes in the fruit section. Now slipping and falling and breaking her ankle. The store manager was not sure how these grapes got there or how long they had been there. But the store policy was to do checks every 15 minutes of the floor in the fruit section. The store manager indicated that there were a number of slippages every week in the green grocery section of the store. I know it's here somewhere. Just wait. Let's look at a case on page 161. We'll come back to this question. It's from the next chapter, but let's look at it now. Safeway and Zaluzna. The respondent, Zaluzna, was injured when she slipped on the wet floor of the appellant's supermarket. So they lost the first instance and they took it to appeal, the supermarket. It had been a rainy day and persons entering the store had made the floor wet. The question again is not whether there's a duty or not, but should the duty of an occupier towards an invitee be treated according to the ordinary common law duty to take reasonable care to avoid foreseeable risk of injury. We'll talk about that later when we go to Springfield. The decision was the duty which an occupier of land owed to someone coming onto the land should properly be seen as the ordinary common law duty to take reasonable care. So they absorbed this into negligence. This would vary with the circumstances of the plaintiff's entry onto the premises, but the measure of the discharge of the duty, again, is what a reasonable person would do by way of response to the foreseeable risk. So they're talking about the breach. Okay, this was then a reason for them to, as I said, absorb it. And in the middle it says, the measure of discharge of the duty is what a reasonable person would in the circumstances do by way of a reasonable response to what was foreseeable risk. However, the court will still take into account how the person came to be on the land in deciding how careful the occupier should have been for that person's safety. Okay. Let's also look at this case. Supermarket cases. Woolworths. Okay. Woolworths operated a Big W store, shopping center, owned by someone, CPT. As part of its lease with Big W, CPT gave Big W exclusive rights to conduct sidewalk sales in the area in front of the store and adjacent to the food court. CPT contracted cleaners to clean the common area every 15 minutes. But inspection and cleaning on the sidewalk sales area, remained the responsibility of Woolworths. Woolworths employed a person, okay, as a people greeter who stood in the entrance. Do you see them still? Who stood in the entrance to the store and was expected to keep an eye out for spillages in the sidewalk area. But Woolworths acknowledged that it did not have anything in place for periodic inspections and cleaning of the sidewalk sales area on the day of the accident. Strong, this is an amputee who had lost part of her right leg, was walking with the aid of crutches. This was on the sidewalk sales area. This was around 12:30 p.m. when the tip of her right crutch came into contact with a chip on the floor, French fries kind of thing, causing her to fall and injure herself, something greasy. After the fall, Strong and her daughter, who was with her, both noticed a grease mark on the floor where her crutch had slipped. Okay, what happened here? Was Woolworths in breach? Okay, decision with the onus of proof lay with Strong to prove that Woolworths' breach was a necessary condition for her fall. Such an onus could be satisfied by consideration of the probabilities in the circumstances where evidence could not establish when the chip was dropped. Okay, so these are the factors that we talked about that you have to take in establishing a breach. The majority said the evidence did not permit a finding as to when the chip was dropped. So on the balance of probabilities, because this is civil, the High Court found that the chip was dropped between 8 a.m. and 12:10 p.m. Okay? Judges sitting there discussing when the chip was dropped. Rather than the shorter period of time suggested by the Court of Appeal, because the Court of Appeal said it was between 12:10 and 12:30, or the time of the incident. The longer length of time opened the way for the court to find that the failure to adopt a reasonable system of cleaning was the effective cause of Strong's injuries or fall. Okay, let's then just go back and talk about a little bit this question here. Okay, so very similar to these facts, but it says now we want to know, and basically want to go through the elements of negligence. What about the first element? Is there a duty of care? Does a duty exist in this situation? Because occupier and this person was basically on the premises. Any problem with that? Is there an issue there? No. What about the next element? What's the next element? Was this duty breached? Was there a breach by the supermarket? So how do you go about arguing that? What do you do?
You have to check whether they did their 15 inspection.
Okay, so you are going to go and exactly do what we talked about on page 136 and 39. This one. We're asking whether there was a breach. So what are you going to do? Ask these questions. Was the risk foreseeable? So how are you going to answer this question? Well, you're going to look at the facts. What are the facts in the situation? What was the risk? Slipping. Okay. Someone coming in and slipping. Is that enough? Were they slipping because it was a rainy day outside? Okay. Here? In the facts for the question? So in the question it says, let me just check again. This is question 6 on page 156. It said, she slipped on some grapes in the fruit section, not in the sidewalks. That's the case in Woolworths. And that's what I really need. It's not important, but usually what you do is really to look at these precedents and see the differences in facts. So say, okay, this is Woolworths, okay, and so on. What is the difference between them? Is that material? But not too much in this course. It's all right. I only want you to know what the risk is. What was the risk here? Just say, what is the risk? The risk was slipping, and is that enough? Slipping on grapes? Grapes or fruit? Grapes? So which risk are we talking about? Fruit? Is slipping on fruit? Why fruit? Because a banana is very different from a grape. So are we talking about bananas or grapes? Grapes. And what else? Is there grease involved? Does that make any difference? Okay. We're talking about the risk of falling on grapes. Is this foreseeable? No. No. Why not?
Because I guess people don't expect grapes to be on the floor anyway.
Okay. So how reasonable is it for some grapes to fall on the floor?
Not very reasonable, because aren't they usually kept in baskets or something?
Okay. So anyone wants to argue the opposite. Remember, there's no right or wrong. Yes?
It is very wrong, but you see it all the time.
You see it all the time.
A store manager said that it happens all the time.
And then it checks every 15 minutes.
Yeah, you just expect it. Usually they can't get to look out for your feet.
So that's what you do here. Did the person, who's the person? The supermarket? The employee, right? The managers, the people in control. Okay? Did they know or ought to have known? Okay. Question 2. Was this risk not insignificant? How would you know if it's not insignificant? If there is a grape on the floor. So what? Are you going to fall? So you see them there all the time. How many times have you seen people fall because of those grapes? Not many times. How about a banana? Does that make any difference? No? Sorry. How about oil? Someone spilled some oil. How about someone that had some grease on the shoes and somehow transferred that into the floor? Would someone slip now? So I'm trying just to say, how is this different from what you saw in the facts in Woolworths? A grape, does it have any grease? Sorry? It has liquid. Is that liquid enough to cause someone to slip?
Yeah, in conjunction with the skin, yeah.
Yes? Small amount. Yes? What are we missing?
How many?
How many? How many grapes? Yeah, what else? Were they squashed? Yes? Thank you. You have also to look at the person. Okay? Does she have crutches? Here we're not told. All we're told, she's regular. See? And she was there also this week. Can you build something around this person? Can you flesh out for us her personality? How old is this person, do you think? Just from the facts. She is regular. Everybody's regular. You could be any housewife or someone, any working mom even. Does that tell us anything about this person? What about that she was there at least once a week? Is that something that we can use? What about sometimes more than once if there are specials? What is that telling you about this person? What kind of a person are you looking at? Someone who would go more than once if there are specials. How old are they? Sorry?
Well, they could be a university student.
Okay, they could be a university student.
An older person who's living on the pension.
Okay.
They could be a housewife who's got 5 kids to feed. You could go 20 billion.
So, can you argue both ways? Can you infer something
Yes.
or negate?
Yes.
That's where you get the marks. It's not just that you give me an answer. You have to be critical. Okay, so what about the breach then? We said that, is it not insignificant? You can argue both ways. We're not done yet. You have to go and look at these most important factors, the ones that decided Woolworths. In the circumstances, would a reasonable person have taken precautions? Would the manager have taken precautions? And we saw that the manager said yes. So it says what? The store manager indicated that there was a number of spillages every week in the green grocery section of the store. Okay? So the store policy was to do 15 minutes. What's so special about 15 minutes? What is the question trying to make you do?
Telling you that the spills occur regularly.
Yeah, but why 15 minutes? Where are they taking you? To where? To the Woolworths case. So this is supposed to bring Woolworths. So you have to bring Woolworths. You have to say, okay, something similar happened in Woolworths. This is the difference between them. This is the similarity. That's why the 15 minutes. To remind you, Woolworths. Now, if you don't have Woolworths, what about these factors? Just from scratch. Probability the harm would occur if care not taken. Is care taken? 15 minutes? Okay. Likely seriousness of the harm. If you slip, regardless of your personality, of your profile, old or young, is that going to cause you some physical injury? Serious physical injury?
Depends on how bad the fall is.
Likely that's going to be bad, or likely it's going to be not bad? Unlikely to be bad. So there will be harm, but not too serious. Or you could argue otherwise. Remember, always, it's always gray. There's no right or wrong. Burden of taking precautions. What are the precautions here? Cleaning up which is their store, because they are a big. Is that reasonable? 15 minutes? Have you seen someone clean the Coles where you go? How often do they do that? Have you noticed? Have you been there long enough to see someone doing the cleaning twice?
You don't probably stay in the store long enough.
Long enough, okay. Oh, that area long enough. What about the social utility of the activity that creates the harm? What's the activity that created the harm here? Shopping, making profit, right? Business. Is that a social utility? No? Why not? Where are you going to get your grapes from? That's social utility. No? Someone wants to argue alternatively, it's not social utility. Why is it not social utility? Because I'm paying you for it. It's not something that you are doing for free or the taxpayer is paying for. So it's not social utility, is it? Or is it not? So that's what we want. You want to see that you could argue it either way. That's the law. The law is about being able to convince someone otherwise. You start with something, I can convince you it's the other way around. All right, maybe we can go for just one more and quickly. Let's do this one. It says, a bush fire brigade had a vehicle specially modified to handle a large jack used in certain emergency situations. The vehicle was being used on another call when an urgent call came through for the use of the special jack at a serious accident close to the fire brigade's headquarters. The officer in charge ordered that the jack be placed in the back of the only other vehicle at the fire station. On the way to this accident, the driver brakes suddenly at an intersection and the jack shifted, injuring one of the firemen. Excuse me. Can the injured fireman successfully sue his employer on the basis of the negligence of the officer in charge in place of the jack in a vehicle not specifically built to? Parties, employer, employee, objectives, this guy wants money, compensation for his injuries, he was injured, physical injury, premise, negligence, elements, existence of a duty of care. Does a duty of care exist in this scenario? Yes. Why? Because, as Damon said, because this is one of the settled cases between an employer and employee. I don't have to worry too much about that. The breach. Was there a breach? So you go through the same questions we just looked at, and you drip down all the way to social utility. Was there any social utility in what these people were doing?
Yes, because it's people working together.
And because they are trying to
Help other people.
which are in distress.
Yes.
It's an emergency call. What is the peculiar fact here? Something that doesn't look nice. Something that doesn't look right. One thing that will make you go, why? I will tell you why. Because you don't have enough money. Because you only got one vehicle, maybe. Something more important. Something, but for, none of this would have happened.
Because they were at another distress.
Because they're at another distress, yeah, maybe. You see, I never say yes or no, maybe, yes?
The jack wasn't secured properly under the place of the safety.
Okay, they did it in a rush. Do they have to? Maybe? Something else happened here. Who said that? Yes. So, why? The driver braked suddenly at an intersection. Does that surprise you?
Well, that probably what's. Well, it says it. Well, yeah. Yes, well, like that's the thing is this is an emergency. They shouldn't have to brake at an intersection.
It does.
Okay, Damien, when you go out and you see a fire brigade in the rear mirror, what do you see usually happening? Everyone move to the side. Any reason that you have to brake? What was it? A wallaby?
Could have been another car coming in from the intersection, not realizing.
Okay.
So it could have been to avoid a possible collision.
Okay. Maybe he saw a shredded tire. That doesn't make sense. So that's what I want you to pick up on. See? If you can say that there was a problem there, this is not in your answers, right? In the answers. If you can, and I don't care, because what we are trying to do is to unpack it. What you want to do is to sow some doubt here. Breaking suddenly, outside everything else. Whose responsibility is that? If you can find someone else who did not move to the side, who did something they shouldn't have done, who tried maybe to race with them, you go after them.
So you should actually go after the victim who didn't break it.
I don't know. I don't know why he did that. So I'm just saying you bring it up, why this happened. Maybe there was something where someone else could be held accountable.
So theoretically, you're saying that the person who kept going instead of braking when they heard the sirens and caused the fire truck to have to forcefully brake at the intersection, you're saying that person could also be liable for the injury?
Absolutely. If that's the case. We're inventing. I don't know what happened. Okay, so basically that's what you have, is social utility. You can read that on your own. All right, I think we're going to break now. We will do some of these later. We will do them later, all right? We'll do some of them in Springfield. That's it for today. Thank you.